live from the drama-free true crime destination. No doubts, no delays, just the facts, the fire, and the finality that stands tall. This is the final word.
Come to order. The Honorable Stephen Hitler, presiding judge.
Be seated. All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me. Period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates, in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Koberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000, and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that are that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Koberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Koberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Koberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Koberger's name, Brian Koberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Koberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow, that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defendant's car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kayla Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single-source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single-source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her also with a large knife. Ethan Chapin, Zamet's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Koberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Koberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Koberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Koberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Koberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Koberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Koberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. And we'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right,
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. And we have breaking news. Court TV can now confirm that the father of missing 7-year-old Emmanuel Haro has admitted to killing his son. Just moments ago, we got the court documents that say Jake Haro, there he is, has pleaded guilty to all charges, including second-degree murder. Reporters in the courtroom say that at today's hearing, Haro was visibly emotional, crying as he admitted to killing his own infant son. Jake Haro will return to court on November 3rd, next month, for sentencing. Now, his wife, Rebecca, she also faces murder charges in connection with the case. So far, no details yet as to whether or not she will change her plea. Her next court date is this month. That is set for October 28th. Baby Emmanuel was reported missing back in May. His remains have not been located. Hopefully that will be coming. Let's bring in now criminal defense attorney Laura Yaretzi. And Laura, good. I'm glad that he has entered a plea if he did this, which he says he did, murdered his own infant son, but still the missing piece of where the body is. What are your thoughts?
There's always a possibility that he may cooperate with the prosecution and law enforcement to get some leniency as far as sentencing is concerned. And as part of that, he may tell them where the remains are or give them specifics as far as what happened.
That's right. That's what we're hoping for in the name of justice for this little beautiful baby boy. And the reality of, what do you think about, because we've seen cases in which a defendant is either convicted of murder of a child or in the alternative pleads guilty to murder of a child, but they don't show emotion. The reporter inside the courtroom has said he was very emotional as he entered this plea. Does that say anything to you?
I mean, it shows you that that's a father who's lost a child, but it may mean that maybe there was some negligence or accidental killing, or maybe he wasn't in the right state of mind, or he was under the influence of drugs. This is somebody who basically cares or cared about the child and is showing emotions, and maybe he's basically feeling sorry for what he did. And that could go a long way. Remorse is in cases like this.
Yes, and we'll see whether or not there's more remorse shown by the father. Again, he has pled guilty to the murdering his own son, Emmanuel.
Welcome back to Court TV Live. Let's get you back inside of this Florida courtroom where we are watching together a plea hearing for a man who is about to plead guilty to the killing of Madeline Soto. It's Stephen Stearns.
Just one day before his sex crimes case was to begin, Stearns reached a plea deal. He is accused in the death and sexual abuse of 13-year-old Madeline Soto.
Let's get back in the courtroom now, picking up right where we left off. The judge is conducting what's called a colloquy, where you make sure that this defendant is accepting this plea deal free and clear of any pressures. And he's asking him if he's been explained about what life in prison without parole means.
Yes, Your Honor.
And in 24 CF 632, counts 1 through 8, the maximum potential sentence would be a mandatory sentence of life in prison without possibility of parole. 9 through 13 and 14 through 20 would be first-degree felony allegations with a maximum potential sentence of up to life in prison. You understand those maximum potential sentences on that case?
Yes, Your Honor.
Do you understand that you have a right to have a jury trial as to each of these allegations? And at the jury trial, the state of Florida would have to prove those allegations against you beyond and to the exclusion of every reasonable doubt. At that trial, your attorneys would be with you. They are experienced, board-certified criminal expert trial attorneys. They would be cross-examining witnesses, examining the evidence against you. You would have a right to present your own witnesses and your own evidence. If you had witnesses that did not want to come to court, you could have asked me to make them come to court with a subpoena. You could have spoke at your trial, or you could have exercised your right to remain silent and not spoken. That would have been your decision after you talked those decisions over with your attorneys, and your jury would have been instructed not to consider your decision to remain silent in any way in rendering a verdict. You would have had a right to have your trial recorded and appeal any errors that occurred in the process. Do you understand you are giving up all of your trial rights if the court accepts this plea? Because I will be imposing the sentence that you have agreed with the state of Florida to be imposed upon you, and we will not be having a trial on any of these matters. Do you understand those things?
I understand.
And, Your Honor, just for record purposes, counts 9 through 13 are first-degree felonies punishable by life, as the court indicated. Count 14 through 20 are actually life felonies.
These are life felonies with a minimum mandatory of 25 years. Is life a required sentence, or would that be a punishable by life offense?
It's a life, punishable by life offense. I just wanted the record to be clear. This court indicated first-degree felonies, punishable by life. I just wanted the record to be clear that 14 through 20 are life felonies with 25-year minimum mandatories.
So the plea form indicates that these are first-degree felonies. These are actually either capital offenses or punishable by life offenses. Do you understand that, Mr. Stearns?
Yes, Your Honor.
Is anyone forcing you or pressuring you into make the decision to resolve your case this way?
No, Your Honor.
Has anyone made you any other promises other than what has been presented to you as the agreed-upon sentence?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you are making?
I am not.
Do you understand if you are not a United States citizen, that entry of this plea would subject you to deportation proceedings?
Yes.
And if you ever before had been convicted of a sexually violent or a sexually motivated offense, entry of this plea would have subjected you to involuntary civil commitment at the conclusion of any incarcerative sentence. Do you understand that's the state of Florida law?
Yes.
Ms. Smith, do you have any competency concerns regarding Mr. Stearns' fitness to accept this plea agreement?
No, Judge.
Ms. Borden?
No, Your Honor.
Mr. Stearns, based on your responses to the court, based on your indicating that you have reviewed this decision with your attorneys, based on your initialing of the plea form and your acknowledgement that you understand all the terms and conditions, rights and obligations on these plea forms, including the addendum, the court is going to make a determination that you are alert, that you have had an opportunity to discuss this with your attorneys, that you are making this decision freely and voluntarily and without coercion. The court accepts your plea. Let me see the attorneys.
Let's bring in John Day, trial attorney, still with us as we watch this hearing take place and unfold before us. Stephen Stearns there, the judge accepting the plea. John, what are your thoughts?
Judge accepted the plea for the defendant. Death penalties off the table, guaranteed life in prison without the possibility of parole. You always wonder what is going through the defendant's mind. Is it a sense of relief, knowing his future? But more significantly, what's going through the minds of the victim's family? Is it relief that they got closure? Did they get the justice they wanted? Did they have to face a trial and the possibility of years of appeals? So it's always a question, how do the victims' families feel at that moment when they see the plea being accepted?
Oh, yeah, I've got a lot of questions about the main victim family member here, and that's the mother of Madeline Soto. We have to take a break. John Day, thank you for your analysis, but certainly we'll be asking that question. Is Jen Soto inside of this courtroom, and could she be seeing the inside of a courtroom in a different way now that Stearns has taken a plea? Breaking news out of Kissimmee, Florida. The court has accepted a plea deal involving Stephen Stearns, where he is expected to enter guilty pleas to not only the killing of Madeline Soto, but countless counts of sexual exploitation, sexual battery, child pornography involving his girlfriend's 13-year-old. We're going to get you back inside of that courtroom right now, where we see Stephen Stearns inside of that courtroom in between his two attorneys and the prosecution saying what they are offering in exchange for taking the death penalty off of the table.
Court has had discussion with the parties regarding the plea of no contest as to 24 CF 1293, the first-degree premeditated murder of Madeline Soto. Mr. Stearns, how do you plea to first-degree premeditated murder in 24 CF 1293?
No contest.
And as to counts 1 through 8, capital sexual battery of Madeline Soto while she was under the age of 12. Counts 9 through 13, sexual battery of Madeline Soto between the ages of 12 and 18. And counts 14 through 20, lewd or lascivious molestation. How do you plead?
Guilty.
Now we're going to turn our attention to Utah, where earlier this week, Catherine Rastelli pled guilty to killing her husband with the help of her mother and brother. Matthew Rastelli was shot and killed on July 12, 2024, when he went to Utah to pick up his wife, Catherine, or so he thought, at her mother's house. Upon arriving, Catherine's brother, Kevin Ellis, shot Rastelli in what he told police at the time was self-defense. However, details of the shooting seemed very suspicious to police. They later uncovered messages and searched histories that indicated that Catherine's desire was to get rid of her husband. Then she decided to plead guilty. Let's go into court now and watch as Catherine Rastelli says, "I did it."
Ms. Rastelli, this is Judge Griffin. Can you hear me?
Yes, Your Honor.
All right. Did you read the statement of defendant in support of guilty plea that was prepared for you by your attorney, or did he read it to you?
Both.
All right. Do you have any questions regarding the information, the warnings and rights that are contained in that document?
No, Your Honor.
Did you read carefully the factual basis of the admission of facts to support the elements that was contained in there as well? Did you carefully read through that?
Yes, Your Honor.
All right. Do you have any questions or concerns regarding those facts?
No, Your Honor.
I'll come back in a minute, but let me ask you this just to tee it up. Are any of the facts contained in the admission of facts incorrect, misstated, overstated, or otherwise wrong?
No, they seemed correct. They are correct.
They are correct, or they seem correct?
They are correct.
All right, thank you. I'll rely upon the rights that are contained in the statement in advance of plea. I'm going to go over your rights with you one more time because you are pleading guilty to several felonies. By pleading guilty today, you've already had your preliminary hearing, but by pleading guilty today, you are giving up the right to a speedy jury trial of your peers. You're waiving the presumption of innocence, and you're waiving the right to require the state to prove your guilt beyond a reasonable doubt. You're also giving up the right to call witnesses to come testify on your own behalf, and you're giving up the right to cross-examine any witnesses who may be called to testify against you in any proceedings, including at trial. By pleading guilty today, you're also giving up the right to present evidence through third parties as well, or through experts, present any type of evidence on your behalf. And with a guilty plea, you're giving up the right against self-incrimination. What we mean by that is when you plead guilty, you've agreed to waive your right to remain silent and testify against yourself. Now, the statement in advance of plea states that you're pleading guilty to 2 second-degree felonies and a first-degree felony. Counts 1 and 3 that you're pleading guilty to, the agreement is they'll run consecutive. Second-degree felony is punishable by 1 to 15 years in prison. First-degree felony, in this case, is punishable for 5 years to life in prison. So rather than consecutive, that means you would serve each one separately, and then after the time it is served on those, then you would serve the time on the third one. If I ran that consecutive, or if I ran it concurrent, you'd be serving the time on the third one all at the same time. I don't know how I'm going to sentence you on the third count or count 2 or the third charge. I'll make that decision at the time of sentencing after I've heard from you, your attorney, I've read the pre-sentence report, I've heard from the state and the victim's family, and then I'll make a final decision. I'm just required to let you know that for each second-degree felony, it's punishable by 1 to 15 years, and then for the first degree, it's 5 years to life. I did have a question I neglected to ask counsel in chambers. There is a firearm. Is there a firearm enhancement with a mandatory, like 3 years or something like that? Is that in play, counsel?
I don't believe so. Yeah, that would be my understanding as well.
Okay, I just wanted to make sure we didn't miss something there. Okay. All right. All right, then you also have the right to be sentenced to not less than 2, not more than 45 days from the date that you plead guilty. The important thing to keep in mind is prior to the time you're sentenced, if you believe it's appropriate, you could ask for permission to file a motion to withdraw your guilty pleas. That motion may or may not be granted. It's fact specific, but it's a right you have until you've been sentenced. Are you under the influence of drugs, alcohol, or medications right now, Ms. Rastelli?
No, Your Honor.
You feel like you're thinking clearly?
Yes, Your Honor.
Has anybody tried to force or coerce you into entering into this plea deal and to waive your rights?
No, Your Honor.
Mr. Brown, for the record, did you explain to your client her constitutional rights? And do you believe she understands them?
I did. Yes, she does.
And do you also explain to her enhanceability, Second Amendment, immigration consequences as applicable?
As applicable, yes.
And Mr. Rastelli, do you wish to waive your rights to proceed forward?
Yes, Your Honor.
And before I do that, just for the record, you did give Mr. Brown permission to sign your name electronically to the statement in advance of plea?
Yes, Your Honor.
All right, I'll find you've only voluntarily intentionally waived your rights. I'll execute the statement in advance of plea now. We talked at the very beginning some of the factual basis for this matter. Mr. Brown, for the record, you went over the mission of facts to support elements contained on pages 2, 3, and 4 of your claim. Is that correct?
That's correct.
And you read that to her verbatim?
Yes.
All right. And you told me those omissions of facts to support the elements are correct. Is that true, Ms. Restelli?
Yes.
All right. So was there a stipulation as to how we're going to handle the facts, counsel? I believe we talked about it. Let's have you put it on the record now. Let's have the state do that first.
The state is stipulating that the facts contained in this agreement are great and sufficient to support the plea on the 3 counts. We agree that if Ms. Restelli is, as she has acknowledged, agreeing that these are the facts, that we don't need to read the entirety of the facts on the audio record because they will be in there written.
Mr. Brown?
Yes, we agree to incorporate them via the plea statement.
All right. I'll set the party stipulation that the statement of facts have been incorporated in there. Do you have any objection to that as well, Ms. Restelli?
No, Your Honor.
All right, good. Then formally, then the facts that contained in the omission of facts in the statement of advance of plea, are those true and correct?
Yes, Your Honor.
All right, I'll find the factual basis to proceed forward. Then is to count 1, murder, domestic violence, a 2nd-degree felony, punishable by 1 to 15 years in prison. How do you plead?
Guilty.
As it pertains to count 2, conspiracy to commit murder, domestic violence in Utah, 2nd-degree felony. How do you plead?
Guilty.
As it pertains to count 3, felony discharge of a firearm, domestic violence, a 1st-degree felony. How do you plead?
Guilty.
Thank you. I'll find you've knowingly, voluntarily, intentionally entered the pleas. I will receive the same, and I will dismiss the remaining counts.
Thank you, Your Honor.
And then you formally waive time, correct?
Yes, we'll waive the time, and I'm available on that date, so I'll work.
September 9th at 9:30 work for the state as well?
It does, Judge.
All right, September 9th at 9:30 live, courtroom 2A. So I anticipate there may be several letters that may be filed. Let's make sure they're filed at least a week in advance. And then once your side's letters have been filed, would you email FACC the opposing side and let they know that they're there, so I can read them and think about the information contained in them instead of struggling early that morning to catch up with a whole bunch of things. Typically speaking, obviously the defendant has the right to address the court. She may have 1 or 2 people she wants to address before. I think the rest should be done through written statements. The state may have a couple of people or may not that want to address the court. That would be appropriate as well. Public balance should be done through written statements as well.
So the court knows we currently plan on flying out the victim's mother and brother.
They would be the
one speaking. Yes.
That would be fine. And we have the family members, just have them submit a statement in writing, please. Any objection to that, Mr. Brown?
No, it's fine. The only, I guess, contingency is if we have some people that can't travel, maybe they can appear and maybe WebEx.
Yeah, we can set up the WebEx. Just let us know the day before, or a day or 2 before. We'll make sure WebEx. Well, we'll try and make sure WebEx is actually right. Anything else we need to put on the record for the defense?
Well, thank you.
Anything from the state?
Thank you, Judge.
All right, thank you, gentlemen. Thank you, Ms. Restelli. I'll see you. Pardon? Oh, yeah, nearly forgot. I do want to PSR, Ms. Restelli, you need to get from the deputies a APMP packet. You need to fill that out completely. If you have any questions regarding any of the information they're requesting from you, don't let it go. Contact Mr. Brown will be happy to help you. If it's not filled out, or if you don't cooperate with APMP and they ask for me to continue sentencing, we'll just have to continue. It'll be another 45 days before we're ready to proceed forward. So it's in your best interest to make sure, Mr. Brown, obviously very experienced, reach out to him and he'll be able to help you on any issues you may have.
Thank you, Your Honor.
All right, thank you.
Thank you.
All right, don't see it a lot of times. Defendants admitting what they did in pleading guilty. Catherine Restelli, she'll be back in court September 9th for sentencing, and there'll be a lot on the line there. You heard the judge say that she's facing 3 separate felonies. 2 of them are 2nd level with a max of 15 years, but as part of this agreement, they are to be served consecutively. So one and then the other, meaning that You're looking max at 30 years, probably comes in around 25, and then the big daddy is a 5 to life. That's where his honor will decide whether or not she sees the light of day. Ashley Bargainquest is watching along with us, and Tinez, as they call it, Martinez, California. Ashley, happy Friday to you. This decision by this defendant, we don't see it a lot. You know, a lot of times people want to roll the dice and go to trial. She clearly wants something to look forward to, and that is the opportunity to see the light of day outside of prison walls. But she's not expected to testify necessarily against her family in that she's being sentenced. You know, a lot of times we see them plead guilty and then you don't get sentenced till after the other trials. Not the case here. She's just really putting her fate in the hands of the judge. Your thoughts?
Yeah, thank you so much for having me. And it is interesting to see the pieces that are missing from a deal like this that you would usually see. Because as you've indicated, we don't have the she will testify in the trial. Sentencing isn't being put over until after that trial. We don't have these same kind of protections that you would expect in admitting such serious charges and facing potentially life in prison. So there has to be something else going on that we just don't quite know. I am sure that the very specific stipulation of facts in this case was exchanged many times between counsel, because if she is not promised to testify, then it is that agreed to facts that a prosecutor would likely be depending on.
Yeah, you know, and there's got to be a deal where prosecutors are going to recommend, you know, 25, 30 tops. Otherwise, you wouldn't enter into this deal. But the judge at the end of the day is going to have to sign off on it. It's a fascinating case. I'm a little disappointed that they didn't read all the facts into the record there, because they stipulated that throwing the police report in, because the facts were crazy. In this case, basically, she doesn't like the ex. They're still married. Lures him to Utah with this story of, I can't drive, my foot's broken, can you help me back? And yeah, I'll do it, because he wants to save the marriage. And waiting there is the brother and the mom, and they're all there, and they kill the guy and then say it's self-defense, and it wasn't. She's busted. What a case. And the other two still going to trial. Their case is still pending. She'll be back in court September 9th.
Breaking news out of Arizona, where defendant Christopher Schultes has pleaded guilty to second-degree murder in the hot car death of his 2-year-old daughter, Parker. Schultes was in court a short time ago. Our cameras were not allowed to film it live, and we are still waiting for more details. But here's what we know. He was expected to stand trial on Monday. Investigators say he left his daughter in the car for almost 3.5 hours, strapped in a car seat while he was inside that house playing video games. This plea comes after Schultes already rejected a plea deal by the prosecutors. The Pima County Attorney's Office released this statement just a moment ago. It reads in part, "Today, Christopher Schultes accepted a plea agreement and pled guilty to 1 count of second-degree murder and 1 count of intentional child abuse under circumstance likely to cause death or serious physical injury." Under the terms of the plea, the sentences imposed by the judge are going to run consecutively, and Schultes will face a sentencing range of 20 to 30 years of flat time, meaning he's not eligible for early release. He must serve the full sentence imposed by the court in the Department of Corrections. That sentencing will be determined by a Pima County Superior Court judge on November 21st. And of course, Court TV will keep you updated on everything that happens in that case. Before we get you back to court, we have developing news out of Kansas City, Missouri, where 86-year-old Andrew Lester has pled guilty to the 2023 shooting of Ralph Yarl. Lester appeared in court this morning in a wheelchair. Also in the gallery for the proceedings were victim Ralph Yarl and his family.
Remember, Lester shot that then 16-year-old Yarl after the teen rang his doorbell by mistake while looking to pick up his younger siblings. He had gone to the wrong house. Lester was scheduled to stand trial next week on charges of first-degree assault, but he ended up pleading guilty today to a lesser charge of second-degree assault, which carries a sentence of up to 7 years in prison. Now, after the hearing, we heard from the prosecutor in the case. Take a listen.
We recognize the trauma caused to Mr. Yarl, his family, and the community due to the tragic incident that occurred on April 13th, 2023. This outcome ensures accountability for the defendant, provides closure to Mr. Yarl, and satisfies the need to achieve a just result in the case.
The prosecutor says he plans to ask for 5 years in prison. Sentencing is scheduled for March 7th. Court TV Live, I'm Ashley Wilcott. Thank you so much for being with us. Now let's turn to New Jersey, where actor Gary Busey is back in court today. He is accused of inappropriately touching 3 women during the annual Monster Mania convention. The women claim he touched them during photo shoots. Busey does deny those allegations. There he is. There's a picture of him. We want to go back into court now for the very start of that hearing.
And how many counts was in that indictment, Mr.
It was a 5-count indictment, Your Honor.
So he's pleading guilty to count 1, so the remaining counts 2 through 5 are being dismissed, right?
Those will be dismissed at sentencing, yes, Your Honor.
Okay, so it's a term of probation, fines, no contact with, what are the initials for that person in count 1?
Your Honor, the victim, hold on one second, Judge. The anticipated conditions are really that the defendant have no contact with any of the victims.
If any of the named.
Correct, Your Honor. Any of the named victims in the indictment. If Your Honor wants, I can put the initials on the record.
Can you do that, please?
Sure.
I think that would be better.
Yes, Judge. Count 1, victim being AD.
Okay.
Count 2 is JE. Count 3 is MH. Count 4 is BB. And count 5, victim's initials are MS. The defendant would agree to have no contact with any of those named victims as part of the plea agreement.
Okay. Counsel, those terms as stated, Mr. Zwillman, is that correct?
Judge, we agree to the no contact, but I disagree with most respectfully for identifying the individuals in counts 2 through 5 as victims, since those cases are being dismissed. But it's just a technical matter. I don't think they remain victims if they're being dismissed.
Well, that's not unusual when there's resolutions and there's more than one named in an indictment. That's not unusual that the state is asking for the terms to be conditions, and I can't control the conditions, that there's no contact with anyone named in any counts. So what do you want to do with that?
We agree to that, Judge. I just don't want the record to reveal that he's pled guilty to anything other than count 1.
It's not going to, why would it do that? Why would it?
Well,
It wouldn't.
because the term victim is still being used for counts 2 through 5. No, not a problem, Judge.
Now, Mr. Busey, we're in a courtroom. Although we are Zoom, you can't eat or drink in my courtroom, although we are on Zoom. You're before a judge. And when you're before a judge, you act accordingly. No eating and no drinking in my presence. You understand, sir?
Yes, ma'am. Thank you, Judge.
Okay. Now, Mr. Zwillman, those terms are stated by the prosecutor. It sounds like you are reserving your right to make what's called the Warren argument regarding the probationary agreement that's going to be entered. Is that correct?
Yes, Judge.
Okay. Now, the other terms as stated by the prosecutor, are they correct regarding this colloquy, this guilty plea?
Yes, Judge.
Okay, Mr. Busey, please state your name and raise your right hand for me.
State your name. State your name.
State your name, sir.
My name is William Gary Busey, B-U-S-E-Y.
Okay, do you, sir, swear or affirm any testimony you give the court shall be the truth?
What? I'm sorry?
Do you swear or affirm that any testimony you give the court shall be the truth?
Yes, ma'am, I do. I confirm that.
Okay. Now, it is my understanding you wish to plead guilty to a 4th-degree sexual contact, criminal sexual contact. Is that correct?
Am I pleading guilty?
Yes.
No.
Yes.
Okay.
I am?
No.
Okay.
No, that's not how it works. Listen to me, Mr. Busey.
Huh?
Did you talk to your attorney about how you want to handle your case today?
Yes.
But I don't want you to say yes, and I don't want anyone to tell you what to say. You need to say it on your own, sir.
Yes.
Okay, now, do you wear some type of hearing assistance,
Yes.
Mr. Busey? Okay, do you have it on now? Okay, do you have it up loud enough so you can hear?
I have it up as loud as it'll go.
Okay. Now, this is my question. Do you wish to plead guilty to a criminal sexual contact today?
Yeah.
Now, I wonder if there's something else that we could do that allow Mr. Boosie to hear a little better. Are you having a hard time hearing altogether, Mr. Boosie? Are you hearing me some?
Yes, I have hearing aids and they are working, but they only go so high.
I understand. And are you still having some trouble hearing me?
No.
Even with your hearing aid on?
No, I don't. I hear you fine.
Okay. So my question is again is, do you wish to plead guilty to a fourth-degree charge of criminal sexual contact? Yes or no?
Yes.
Now, before you decided to plead guilty to that charge, did you review that charge with your attorney?
Yes.
Did you have a chance to read the police reports with your attorney?
Yes.
Has your attorney answered all questions that you've had?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you had enough time to meet with your attorney?
Yes.
Now, this is my understanding of the plea agreement. It is my understanding you will be pleading guilty to count 1 of the indictment. Count 1 charges you with fourth-degree criminal sexual contact. On your sentence date, the state is recommending I sentence you to a term of probation. Could you hear all of that?
Yes, ma'am.
Okay, and do
Yes,
you
Judge.
understand? Okay, you understand?
Yeah.
Okay, now probation will be anywhere between 1 to 5 years. The length of probation and condition of probation will be set by me and my discretion. Do you understand that?
Yes, ma'am. Thank you.
Your fines will be...
Well, we had understood this would be a pre-trial hearing. It's now turning into a guilty plea. I'll tell you, I think that the judge may have almost called it off when Gary Busey initially said no and then talked to somebody and said, yes, he's entering a guilty plea. We're going to pause it there, and we'll get you back inside the Zoom courtroom when we come back here on Court TV.
Tonight on Closing Arguments, jurors are weighing the evidence against 2 parents accused of trying to kill their daughter. We're diving deeper into key evidence as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Saturday nights on ION is our night. Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Staying now on the latest with the charges of sexual misconduct for actor Gary Busey. The alleged incidents took place at the annual Monster Mania convention, and the women claim he touched them during photo shoots. There were 3 different women who claimed that, and he's in court via Zoom. And we found out as we're watching with you that he agreed to plead guilty to 1 fourth-degree criminal sexual contact count. Let's go back in and see what else happens. We paused it where we left off.
$75 safe neighborhood, $33 court costs. You can have no contact with anybody named in those police reports. Do you understand that?
Yes.
Now, your attorney is going to make an argument to ask the court to give you fines only. That's an argument that's an argument that he has a right to make. It'll be my decision if I grant that argument. Do you understand?
Yes, ma'am. I do. Thank you.
Now, all of the other counts in that indictment, it was 5 counts you were charged with in that complaint. It's 5 counts. You're pleading guilty to the 1 count, and all the rest are being dismissed. Is that your understanding of the plea agreement?
Yes, ma'am. Yes, Judge.
Okay, now by pleading guilty to that charge, you have to tell me the facts to make you guilty of that charge. Can you do that?
Yes.
Okay. Also, by pleading guilty, you waive certain rights, which includes the following. By pleading guilty, you waive the presumption of innocence and a right to a jury trial. Could you hear that?
Yes.
Also, by pleading guilty, you waive the right to have the state to prove your guilt beyond a reasonable doubt. Do you understand that?
Yes, ma'am. Yes, Judge.
Also, by pleading guilty, you waive the right to confront and cross-examine witnesses. Do you understand that?
Yes, ma'am. Yes, Judge. Sorry.
That's okay. It's fine, sir. Also, by pleading guilty, you waive your right to present any witnesses on your behalf. Do you understand?
Yes.
And you also waive your right to present a defense. Do you understand that?
Yes, ma'am.
Knowing all of that, do you want to continue with your plea of guilty?
Yes, ma'am.
Are you fully satisfied with the legal advice and services of your attorney?
Yes. Yes, very much.
Okay. Are you pleading guilty voluntarily on your own free will?
Yes, voluntarily.
Has anyone threatened you or forced you to plead guilty?
No.
Has anyone promised you anything to get you to plead guilty?
No, ma'am. No, Judge. Sorry.
Okay, that's all right. And all of these questions are being asked to make sure the record protects you, Mr. Boosie. You understand that?
Yes, ma'am. Thank you. Yes.
Okay. Now, are you, sir, under the influence of any drugs, alcohol, or any medication that would affect your ability to understand what's happening today?
No, ma'am. Not at all.
Do you take any type of prescription medication?
No.
Are you satisfied with the investigation your attorney has conducted on your behalf?
Yes, yes, Judge. Thank you.
Okay. And are you pleading guilty today because you're guilty of a 4th-degree criminal sexual contact charge? Is that why you're pleading guilty? Are you guilty of it?
Yes, yes. Affirmative.
Now, did your attorney review with you a 6-page plea form in this matter?
Yes.
Did he read each question to you on all 6 pages?
What?
Did he read that plea form to you, all 6 pages?
No, I read it myself, but he said it to me.
Okay, but did your attorney review it with you? Besides you reading it, did he review it with you?
Yes.
Okay. Now, did you provide him an answer to each of those questions on that plea form?
Yes, yes.
If I was to take that same plea form and read each question to you, would all of your answers be the same that you gave your attorney?
Yes.
After your attorney reviewed that document with you, did you write your own initials at the bottom of all 6 pages?
Yes, ma'am, and I wrote my full name signature at the end of the 6th page.
Okay, thank you. And that was my next question. Did you sign it? And you did sign that document, correct?
Yes, ma'am.
Now, are you currently on any type of probation or parole?
No, not at all.
Are you a citizen of the United States?
Yes, ma'am. For 81 years, I've been a citizen of the United States. Proud of it.
Okay. And can you read and understand the English language?
So far, yeah.
Okay. Tell me how far you went in school, sir. What is your education?
All the way through college. Senior year at Oklahoma State University in Stillwater, Oklahoma.
Okay. Now, in reference to questions, do you have any questions for me, sir, right now?
No.
Okay. Let's do a factual basis, counsel.
What was that?
Okay,
Your attorney's going to
Mr.
your
Busey,
attorney's.
I'm going to
Hold
direct.
on for a moment, Mrs. Willman. Your attorney's going to ask you some questions for a factual basis for the charge you're pleading guilty to, okay?
Yes, I'm ready.
Okay.
Still with us, criminal defense attorney Ryan Brown. He was laughing. Busey seems okay with this whole thing, but I feel like I also hear somebody behind him speaking in his ear to say how to answer.
Yeah, it sounds to me like there's somebody in the room with him, you know, kind of helping him through questions, which may or may not be a big deal, right? It's not uncommon for a client to look at you when you're doing a plea in person. Hey, I don't understand this question or anything like that. But it sounds like somebody might just be feeding the answers, which is something that a lot of judges may balk at.
Yeah, I would agree with you. Some judges would say, you come back another day once you get this under control, and I know you're the one making the decision. But let's talk about the reality. We thought this would be a pretrial hearing. And Ryan, how often or how does it happen that all of a sudden it turns into a guilty plea? And do you think, we don't know what the sentence is yet, do you think they've worked out an agreement for that to propose to the judge if he's going to offer this plea?
Yeah, so, you know, trials are way more fun to talk about, but a lot of times most criminal cases do resolve short in a plea like this, and it's not uncommon. Maybe the lawyers from both sides prepared to go into a motions hearing today, they get together before court, they're able to come to an agreement. We don't know if there's an agreement yet or not. My guess is there would be one, probably a fine and maybe some sort of probation and counseling or an apology or something like that. But my guess is they were able to reach some agreement that Mr. Busey's counsel were okay with, that the state of New Jersey was okay with, and that we're going to see a negotiated plea here shortly.
Especially considering he's 81 years old. We know this is in New Jersey because this is where it occurred. The Monster Mania, which we didn't know, but I just want to mention for those viewers who may not know, I thought it was Monster Trucks. I was wrong. But instead, it is an event of horror films where they have memorabilia and they have guests there, and that's the reason I would assume that this is actually being held in a New Jersey courtroom.
That's right. It sounds like this event or get together is there. You know, I imagine some of the conditions of this sentence will be he may not be allowed to go back to Monster Mania, definitely not around any of the victims. And even though he's only pleading guilty to one of the counts, probably won't be able to have contact with any of the folks that were listed as a victim in the original indictment.
Oh, Ryan Brown, thank you so much for all your great expertise being here in person. Coming up, we're going to have more for the hearing for actor Gary Busey. Plus, we're still on a verdict watch in Washington. Stay with us. Welcome back to Court TV Live. I'm Ashley Wilcott. We begin this hour in Washington State, where a jury has been deliberating now. You can see on your clock 17 hours and 42 minutes in the attempted murder trial for Ihsan and Zara Ali. Both the parents are accused of trying to choke their 17-year-old daughter to death after she'd run away from home ahead of a months-long trip planned to Iraq. Joining us live now in studio with all the latest is our own Court TV legal correspondent, Kelly Craft. Kelly, always great to be on with you. Tell me, what is the latest from the jury in this case?
Well, good afternoon to you, Judge Ashley. So day 3 of deliberations, jurors have asked 2 questions so far. Earlier this morning, they came back with their second question. So here's what they were asking. As it applied to the jury instruction 46, is the violation of the protection order for Isaiah or for the building? So that seems to be what's kind of holding them up a bit. They wanted to get some clarification on that. The judge told them to reread the jury instructions, so that's what he instructed them to do, which is exactly the same answer the judge gave for the jury's first question that came yesterday.
Legal authority wasn't defined for count 3, instruction 34. What is the definition of legal authority signed by the presiding juror? My proposed answer is please refer to and reread the jury instructions. Ms. Stone, any objection to that response?
No objection, Your Honor. Thank you.
Mr. Kading?
No objection, Your Honor.
Mr. Larry?
Objection.
I believe that this is the answer that Mr. Larry told the jury that they might receive if they had a question.
And let's take a look at that video. This is something both the prosecution and the defense really focused on in their closing arguments. Defense counsel saying this all comes down to 53 seconds. And the way he is talking about this video, he says, take a look at it. See that Isaiah, Fatima's boyfriend, punches Mr. Ali first. And then defense counsel is arguing, Mr. Ali is confused. He's on the ground. He feels that a mob is attacking him. He just wanted to come and take his daughter home, and his daughter didn't want to go. So he's saying there's no intent here. These charges shouldn't have even been brought. That was his argument in his closing. So again, the juror's been out now. The jury has been out now for nearly 18 hours, Judge Ashley. We are continuing to monitor this, and as soon as there is any movement inside that courtroom, we would be sure to bring you any developments.
Oh, fantastic. Thank you so much to Kelly Craft. Now, let's head back to New Jersey, where actor Gary Busey is back in court today. This is a Zoom hearing, and it turns out he has pled guilty to 1 count of sexual criminal contact after he inappropriately touched a woman at a convention. Let's go back in for more of the hearing.
Mr. Busey, I'm going to direct your attention to the date of August 13th, 2022. Okay?
Yeah.
All right. Were you in Cherry Hill, New Jersey on that date?
Yes. Affirmative, yes.
And were you attending something that's been identified as a Monster Mania convention or function?
Yes, sir. Yeah.
Was there a photo shoot set up where fans of William Gary Busey, could have a photograph taken with you?
Yes. Yes.
And during that session, you agree, do you not? You do agree that you inappropriately touched the buttocks of an adult female over her clothing. Is that correct?
Yes.
And you understand now, and you knew then, that that was not appropriate. It was wrong, correct?
Yes, very much so. Immediately, yes.
And you want Judge Blue to accept your acknowledgement of this particular incident. Is that right?
Yes, sir. It is the truth.
I have nothing else, Judge.
Is this satisfactory to the state?
Just that we identified the female victim by the initials AD. Would it be fair to say that you later learned that that victim had those initials?
Mr. Busey, the victim is identified with the initials of AD that you said you touched the buttocks of. Do you agree with that, sir?
Yes.
Okay.
Nothing further, thank you.
Keith, I don't have the indictment in front of me. There's no gratification or anything. This is a touching, right?
Well,
Looking at the indictment.
I think that is under the statute part of the purpose of the touching. So counsel could address that specifically. That would be helpful as well.
Mrs. Willman, you need to fill. Mrs. Willman, you need to fill in the record more as to what his purpose was when he touched her buttocks. That's what I thought. I don't have the indictment in front of me, but there's something missing from the factual.
All right, I just wanted to indicate also, Judge, that the actual victim's name is in the indictment. We're not using that for this purpose today.
No, we use the initials. That's what we use, the initials.
Mr. Busey, I just want to ask you that you understand that it's only a violation of the law that you could plead guilty to if you intended to gratify yourself by committing that act. I've told you that, correct?
Correct what?
The touching of the buttocks was done for your gratification.
No, I was looking, my eyes were on the camera lens. I moved my hands up and grazed her buttocks without thinking and without looking.
That's not a factual basis. That's not a guilty plea.
What?
Mr. Busey, I've advised you, and we agreed earlier, that in order to plead guilty, you have to truthfully acknowledge.
I truthfully acknowledge
that you did this for your own gratification as opposed to any request by AD. Is that correct?
Yes.
Okay. Thank you, Judge.
So this was not an accidental touching. You purposely touched her. Is that correct, sir?
Yeah.
Okay, and you did it for your own self-gratification. Is that correct, sir?
Yes.
Okay. Any other questions from the state?
No, Your Honor. Thank you.
Okay, Mr. Busey, do you understand that by pleading guilty, you're going to have a criminal record?
Yes.
Do you also understand you have to submit a DNA sample?
What? What?
A DNA sample. Whenever you're arrested, you have to give a DNA sample, which is a swabbing of your mouth. Do you understand that?
Yeah.
Okay. On the charge of fourth-degree criminal sexual contact, how do you plead? Not guilty. What is this, sir?
Guilty.
Okay, sir, I find based on your statements under oath, I find your guilty plea is known and voluntary. It's a factual basis for your guilty plea. Your guilty plea is accepted. Your sentencing, counsel, you're asking that he does it, that he could do a sentencing by Zoom, correct?
Yes, please, Judge.
Okay, your sentencing will be October 3rd by Zoom.
Judge,
June?
October 3rd.
No, October 3rd. Well,
Oh, okay. Gotcha. 5-3.
Judge,
10-3.
I'll have to discuss it with my client. I do have a very serious surgery scheduled for September 22nd.
I can do it before then. I can do it before that. I can sentence him. I can definitely do it before that.
Okay.
I will make it September. You want to do it? Let's do it on an off day. We could do September the 18th on the Thursday instead of my big Friday sentence day, okay?
Let me just check, Judge. Thanks.
Get that?
Yep. I'll tell you your date in one moment, sir. Joey, you called for someone to do his interview?
What?
No,
Yes,
not you, sir. One moment, Mr. Boosie.
Judge, what time would that be?
We could do it at 9 o'clock on September the 18th. I said that's on a Thursday.
I have another, I don't know, I don't want to mess up the court schedule. I have something at 9. It's a lower court, but it's an old DWI case. Can we do this later in the morning?
Why do I have to wait for a lower court? I don't understand.
You don't.
Oh, why don't we do this, counsel?
As a matter of fact, I have no problem saying that Judge Blue told me I got to be there at 9.
What court would you have to be in on the 18th?
That would be Parsippany Troy Hills, but
okay, why don't we do, I can do it this, because I'm doing a sentence on September the 11th. How about the 25th? Are you available on the, well, that's close to your surgery. How about the 23rd? That's on a Tuesday, September the 23rd.
Oh, I'll be in the hospital.
Oh, that's that week you go in.
Yeah, but
because this sentence is fast. Why don't we do this at 9? And it's going to be by Zoom, so you could be wherever you are. It's going to be by Zoom, right?
All right. Well, then we can do. I'll work it out with the lower court, who will, I'm sure, be subservient and acknowledge Your Honor's position.
They may not, but you'll have.
You know what?
You'll have.
That's their problem, right, Judge?
Right. That's right. Because you'll have to come. You can't be in 2 places at one time.
No. And I'd rather be with Mr. Boosie here. So if I had a preference.
This sentence will be really fast. It takes, 15 minutes to do a sentence, so it won't be long. Okay, Mr. Boosie.
What date is that, Judge?
September the 18th. That's on a Thursday. Write it down, Mr. Boosie. September the 18th at 9 o'clock a.m.
9:18, 9 o'clock.
Yeah, and it's gonna be where you are. You're gonna be able to come by Zoom the way you're doing it now, okay, for your sentence.
Yes, ma'am. Affirmative.
Now, I did make my record. I do find, as I said, that you've not only voluntarily entered your guilty plea. Your guilty plea is accepted, and that will be your sentence date of September 18th at 9 o'clock. The next step today, Mr. Boosie, is someone is going to come on the screen, a probation officer. They need to do what's called an interview with you to prepare a pre-sentence report. So you need to stay on the screen until we tell you that you can step off, okay?
Yes, ma'am. Affirmative.
All right.
Judge, I'd like to stay with him on that.
Absolutely. Okay, you're going to go in the breakout room when that probation officer come on. Do we know who's doing it, Joey?
I don't yet. I'm going to reach out and make sure right now.
Because I need to rest my back.
You need to step away for a moment. You can, Mr. Boosie, but just come back on, okay?
Thank you very much.
You're welcome.
Judge, is your trial over?
No. Will Mr. Brennan and Mr. Stas. Who was asking about the trial? I'm sorry, who was that?
I asked, Mr. Swain.
Oh, no, it is. They came back with a verdict today, so it's over. Yes. Any attorneys back on, Mr. Stas and Mr. Brennan?
Yes, Your Honor.
Where's Mr. Stas? Is he on?
Yes.
Put me in the breakout room with these two attorneys, Mr. Brennan and Mr. Stas, please.
Your Honor, may we be excused on the Busey matter?
Yes.
Thank you,
And
Judge.
Mr.
Have a good
Boosie's
one.
going to stay on, and Mr. Swillman is going to stay on so he can be with his client for the interview.
All right. Thank you, Your Honor.
Okay, thank you.
Oh, excuse me. All right, that's over. I want to bring in National Trial Attorney Madeline Somerville to help break this all down. Madeline, it was an interesting Zoom hearing at best. We could hear what I believe to be in the background behind the defendant, Busey, someone telling him what to answer. At first, he had said, no, I'm not pleading guilty, and his attorney got him through that. And then he said, no, I didn't have any intent to gratify myself. That's an element of the crime. The attorney said, remember, we went through this. You have to agree to that if you're going to do a guilty plea. What are your thoughts at the end of the day as to the fact, yes, the guilty plea was accepted?
Well, thank you so much, Judge Ashley, for having me on. I'm always so happy to see you. So this is always a difficult situation, and I'm sure that it's not this judge's first rodeo. What we saw here was Mr. Busey, and I always thought it was pronounced Busey, so I'm glad I have it correct now, kind of trying to walk things back. My guess is that he was embarrassed, and it's quite often the case that you have a conversation with your client, and then when it's time to stand up and do the thing that you had actually prepared for, that the client gets nervous. It's difficult to admit that you touched someone for the purposes of gratifying yourself. And so if he was going to concoct some story, right, like we heard him say, it was something like, I raised my hand and I accidentally touched the back of her. You know, it's quite embarrassing, and it's difficult. And so I don't think the judge held that against him. But again, this obviously wasn't her first rodeo, and so she was patient with him.
And you're right, Madeline. You and I have both had cases, represented clients, where you can go over and over and over what they decide to do to explain it all, and you get in court and you're like, oh my gosh, what happened to my client? That's not the same person I talked to, because they're not remembering anything I've told them. So that is not uncommon at all. What about this, though? As soon as the guilty plea was accepted as knowing and voluntary by the court, she then said, number one, you're going to have a permanent record. That's probably not a surprise. Number two, you have to give a DNA sample all prior to the sentencing, which is scheduled for September 18th.
Mm-hmm. So I think he was a little bit, to use a colloquialism, freaked out when she said something about a DNA sample, right? We were already down the I'm embarrassed path, and now he, feels like a criminal. And you're hoping that he's processing all of this because he's obviously in pain. I don't know why we're all on Zoom. I don't know if they provided that information. I don't know if he's sick, but you're hoping that he's entered into this plea freely and voluntarily, because if he didn't, then there's some recourse for him available in the future if he wanted to change his mind as to how he wanted to plead in the case, or if he wanted to appeal the sentencing that he might receive.
Yeah, good points. All good points, Madeline. And we know in New Jersey, this is the potential sentence that he faces. Up to 18 months in state prison, up to. I don't think he's going to serve any time, but also a fine of up to $10,000. Also potentially mandatory registration on the state sex offender registry. That's the potential sentence. Of course, I'm sure they've already spoken about it to figure out, the prosecutor as well as his attorney, to figure out what they might agree to, and hope that the judge will sign off on that.
We have breaking news to share with you now out of Wisconsin in the case against defendant Taylor Schabusiness. She's the infamous inmate who's known for her violent attacks. Some of them we've seen in the courtroom. She is a convicted killer, and she was set to be in court today for a motions hearing over a case where she allegedly attacked a prison guard and a prison nurse. And the motions hearing was going to be regarding whether she would be shackled during the upcoming trial. But in somewhat of a surprise move, we're getting word that this case has just been disposed of. That's right, Taylor Schabusiness has pleaded no contest, and there's been an amendment to the charges. It's been amended to disorderly conduct, so she pleaded no contest to disorderly conduct. The judge accepted that plea, and her sentencing is set for a month from now. It's set for, a little over a month. I'm getting word it's been set for December the 1st. Now, we are waiting to bring you the video footage from this hearing. So we have it filmed. We're standing by for this to come in into our system, and then we're going to play it for you. It was a pretty quick hearing, but we understand December the 1st will be the date that the sentence is imposed, as she's pleaded no contest to disorderly conduct. All right, no trial for Ms. Schabusiness. Wow, let's bring in our legal analyst guest to get his reaction. Retired district attorney and practicing criminal defense attorney in the private sector, Matt Mangino, with us. Matt, what do you think? We thought this was going to be a battle over the shackles, and we got a little bit of a plea here, a no contest plea, but a plea nonetheless. Your thoughts?
Well, yes, I mean, I can see a plea in this situation. She has life without parole. She's a very dangerous person. We saw her act out in court. We now know that she's acting out in prison, and this is going to continue. And this is one of the questions, Julie, about the death penalty. What do you do with an individual who is just going to, for the rest of their life, while incarcerated, attack people, do harmful things to people? She committed a very heinous crime to begin with. Where does this end? And she has life without parole, but she's going to continue to act out throughout her time while she's in prison.
Yes, that's a great point, Matt. Because we hear the expression that someone is a menace to society, and this woman definitely was while she was out walking free in society. Now she's a menace in the prison system. She really is. She's a problem. She's a danger to the guards, fellow inmates, her lawyers when they encounter her. She's a problem. And you're right, this is not a state that has the death penalty. Wisconsin doesn't have it. It wasn't on the table. As you noted, she's locked up for life. But, a danger in lockup. I mean, she really is. And so I guess in the grand scheme of things, these charges wouldn't have changed anything for her situation. So perhaps everyone thought this is just better to dispose of this case, get her back in a place where we can continue to monitor her and not keep transporting her to court to fight this. So here we have it set for December the 1st, and we're going to work to get this video in so you can see her in this court appearance, again, about 10 to 15 minute appearance. Matt Mangino, thank you for weighing in on that. No trial coming up for Taylor Schabusiness. That is the big news this morning. Wow.
Thank you all for joining me here at the Drama-Free True Crime Destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.